Welcome all to this presentation on all things trust related. We are on to presentation number 5 now, where we will now focus heavily on all things trustee related. So looking at the different duties expected of a trustee, the importance of consent into this role, the trustee's rights in the role, we will cover what a breach of trust is and the liabilities of trustees when there is a breach. So we have lots to cover. Let's get started. So by now, we have to assume that there is a valid trust in existence, right? So we have a trustee, which can be either a professional or a lay trustee, who will be holding on to legal title to property when the beneficial title is owned by someone else. This therefore imposes duties onto that trustee where they will have to act in the best interests of the beneficiary or beneficiaries if there are multiple. And they will be doing so in a fiduciary capacity. Obviously, this role will impose very high standards of conduct onto the trustee, which include loyalty, diligence, prudence, and good faith, just to name a few. When we talk about fiduciary, it is important to be fully aware of what this actually means. So, a really profound description of what a trustee is has actually come from a case law in which Judge Millett L.J. states the following: a fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of a fiduciary is the obligation of loyalty. The principal is entitled to the single-minded loyalty of his fiduciary. So some examples of fiduciary roles include a trustee in relation to a beneficiary, a company director in relation to a company, an agent in relation to the principal, a business partner in relation to their partners, a solicitor in relation to their client, and crown servants in relation to the public. So hopefully you can see that fiduciary relationships are not uncommon, and actually they're very common when you think about it. So let's get into the nitty-gritty about the different duties expected of a fiduciary. So first we have a big one, which is loyalty. So in the context of trusts, loyalty refers to the trustee's obligation to avoid conflict of interest. Practically, this means that the trustee cannot profit from their position and they must not enter into contracts where there is a conflict of interest. A case law example of this is the case of Keach v. Sandford of 1726, where a trustee took on a lease in his own name after the landlord refused to renew it for the child beneficiary. The trustee ended up profiting highly with the profits in his name, but this was held to be a breach of his fiduciary duty, as he was not supposed to profit from his position or place himself in a conflict of interest, even though he only did it because the child beneficiary was just that, a child, and therefore the landlord couldn't renew the lease in the name of the child beneficiary, which seems silly to hold the trustee liable to a breach when it was clear he was doing it in good faith, but unfortunately, good faith is no excuse. The next duty is the duty not to profit. So this just means the trustee is not allowed to make unauthorized profits. Practically, this means they aren't allowed to use trust property or trust information for personal gain, for example, investing the trust fund into their own business. This also means that any profit that they do make from acting as trustee, either directly or indirectly, must be returned to the trust as it is considered trust property. A case that demonstrates this is the case of Boardman v. Phipps of 1967, which we touched on in the last presentation, the trust presentation number 4, when we talked about constructive trusts case law examples. So going into a bit more detail here, what happened was that the solicitor of a trust also happened to be a beneficiary of the same trust. So what this solicitor did, they used the intel about the trust that they had gathered in their role as a solicitor, and they went on to buy shares in a company that the trust had invested in, which naturally increased the value of the shares. So although the increase in the value of the shares actually benefited the trust as a whole, it was held that because they didn't seek the consent of all of the beneficiaries, they have breached the no profit and no conflict of interest rules and had to account for the profits that were made. Next is the duty of prudence, meaning a duty to manage the trust property with reasonable care. Practically, this means investing wisely to avoid risk of loss and taking reasonable precautions to protect the trust property, for example, insurance if this is applicable. So side note here, if you insure property, you may or may not be conducting yourself as a trustee. Just maybe. Then you have the fact that professional trustees will be held to a higher standard than lay trustees, and they will be expected, pursuant to the Trustee Act of 2000, to comply with investment duties, which will include seeking proper advice and diversifying investments as much as possible. So a case that set the standard of prudence is actually the case of Spate v. Gaunt of 1883, where the standard was set that trustees must act as an ordinary prudent business person would. So, for example, they have to seek professional guidance if required. Next is the duty of impartiality. This refers to the idea that a trustee to multiple beneficiaries must act fairly between them all. They cannot take preference of one over the others. Practically, this means a trustee cannot discriminate against a beneficiary simply because they don't like them or because they think that the beneficiary shouldn't have a right to the trust property. This is especially important in trust situations where one beneficiary has the right to the income, whereas another has the right to the capital. A key case that set this standard was that of Cohen v. Scargill in 1985, which detailed that trustees must place the interests of the beneficiaries above everything else, even if the trustee has their own political ideas or moral viewpoints against a beneficiary. The next duty is the duty to follow the trust deed. So this refers to the idea that trustees have to obey the trust deed or trust instrument to the T basically. They must act within the powers given to them in the deed and follow the terms religiously. Practically, this means that the trustee cannot deviate from the trust instructions, and they cannot distribute property to the wrong beneficiary. If any of these are breached, then the trustee can become personally liable for their wrong. The case that set this standard was the case of Tempest v. Lord Camoys of 1882, which set the standard that trustees must exercise their discretion in line with the trust instructions and not their own preferences just because they felt like it, which makes sense, right? Next is the duty to keep accounts and to provide information to the beneficiaries when asked. So practically, this means a trustee must keep accurate records of the trust assets and income and expenses if there are any. Then, whenever a beneficiary requires it, a trustee must give them reasonable access to information about the trust. But this does not necessarily mean full disclosure. A key case that demonstrated this idea about beneficiaries' access to information was the case of Schmidt v. Rosewood Trust Limited in 2003, where it was held that beneficiaries do not have an absolute right to documents related to the trust. It is actually a discretionary right, meaning that the courts may order the disclosure if it deems it fair. To me, this makes sense because, yes, trustees have to be open and honest to the beneficiaries, but there is a fine line between information that the beneficiary needs to know, for example, that the beneficiary is actually a beneficiary and what rights they have to what property, versus a beneficiary that demands all the information as well as the information of other beneficiaries, and also maybe transaction history from forever ago, things like this. Basically, it's as if the beneficiary begins to ask too many questions that the answers should only really be reserved for a trustee, right? I mean, a trustee is tasked with managing the trust and all the technical stuff behind it, whereas beneficiaries are supposed to just enjoy the arrangement. So to me, it makes sense that a beneficiary who is asking for too much is almost trying to take the role of trustee themselves. And obviously, this is not right, and it's almost as if they're trying to act as a trustee, but they would actually be acting as a trustee de son tort, which we will get into what this means later on. Next is the duty to act personally. So this means that a trustee must act themselves and not delegate their role or their core powers to someone else. Practically, this means that a trustee cannot give someone else their powers unless the trust instrument expressed that this is actually allowed. However, there are some powers that a trustee can delegate which are actually permitted under statute, which can be found in, for example, the Trustee Act of 2000. You may be wondering, what is the point of this duty? Well, it's because a trustee is appointed specifically because they are trusted for the role. The settlor could have picked anyone, but they picked that specific trustee or that specific group of trustees. It wasn't by accident. There was a purpose. Therefore, equity will expect the chosen trustee to act personally and not outsource their decisions and powers to other people. And the last duty we will cover is the duty to take control of property. So this means that trustees have a duty to actually gain the legal title to the property that is to be held in trust. They must then insure it if this is applicable, and they must ensure that this property is maintained to prevent its misuse and misappropriation. The point of this duty is that trustees have to gain the legal title to the property, because if they do not, then equity will not protect wannabe beneficiaries. But also, it may actually result in personal liability for loss should something happen to the property, which would place a beneficiary at risk. So the key takeaways from all these duties is that the trustees have power, but it is only to serve the beneficiary's interests, not their own. But of course, with great power comes great responsibility. Equity imposes duties onto the trustee, so in the event of a breach, they will be held personally liable, and that this is a serious role not to be taken lightly. So because with great power comes great responsibilities, not everyone will be cut out for this role, which is fine and perfectly acceptable. No one is obligated to accept such a role if they don't want to. The only exception to this, of course, is if you are acting as an implied or constructive trustee, or if by your conduct you are meddling with trustee duties of a trust when you are not formally appointed as one. So basically, you are acting as a trustee, but you are not, and you were never asked to be one. This is what is known as a trustee de son tort in legal terms. So unless you are a trustee because you were imposed that role by equity due to an implied or constructive trust, or you are acting as a trustee de son tort, under the UK law, no one is obligated to be a trustee to a trust. The only way you can become a trustee is through your express, informed consent, either by words, in writing, or orally, or through your conduct, of course. With great power and great responsibility also comes great compensation. A trustee is not expected to work for nothing. They have the right to reimbursement for expenses that they incur in pursuit of the trust's objectives. This will include expenses in employing agents, legal costs, travel expenses, and things like this. They also have the right to be remunerated for their time spent in the pursuit of the trust's objectives, because no one can be expected to do everything for the benefit of another and have absolutely nothing in return. This is not how lateral law of give and take works, right? There always has to be some sort of balance in the work done and the compensation received. So, until the trustees have been remunerated for their expenses, they actually hold a lien, so a claim, over the trust fund to the equal amount owed to them, which actually takes priority over the interests of the beneficiaries. So they become a creditor of the trust fund until they are remunerated. So how is a trustee actually appointed? Well, in express trusts, they will be appointed in the trust deed itself, and often they sign it as well to evidence their consent into this role. In will trusts, the trustees will be expressly appointed in the will itself. There are two requirements to be eligible to become a trustee. One, you have to be sui juris, which is the legal phrase for 18 or over and also sound of mind. And two, you have to express your consent to be in the role. So you have to be able to evidence this in writing or by conduct. A key note here to remember is that equity will not allow a trust to fail for want of a trustee, which is a key maxim of equity right. So in cases where maybe a trust doesn't have an active trustee in place for whatever reason this may be, then the courts actually have discretion to appoint a new trustee themselves. So now we've covered how to get a trustee. Now, how do you get rid of them too? Well, there may be procedures in the trust deed itself which set out the mechanism for removal in its provision. So looking in the trust deed is the first place to go. Then, trustees can actually remove themselves or other trustees, which is essentially key in cases of death, retirement, refusal to act, incapacity to act, and things like this. Also, beneficiaries who are sui juris and acting together in agreement can direct trustees to retire or to appoint a new specified trustee. And again, the court may actually remove trustees as they have the power to do so in cases where trustees refuse removal or if there is a dispute of some kind. So now let's move on to breaches of trust. What actually does this mean? Well, it's quite simple really. It is when a trustee fails to uphold their duties in some way. In cases of a breach of trust, equity will hold the trustee personally liable for any losses caused by their misconduct, inaction, or even negligence. So yes, it's just when a trustee fails to meet one of their duties, as we have previously discussed. So some examples of breaches could be a trustee acts outside of their powers, a trustee fails to follow certain terms of the trust deed, the trustee neglects their duties, so fails to act when they are expected to, a trustee benefits from the trust property when they aren't actually a beneficiary, and also the trustee distributes assets to the wrong individual or at the wrong time. It is important to know that sometimes trustees act in good faith, so with genuine intention with what they are doing. However, equity does not allow good faith to be a defense against carelessness and breaches. So even though they meant well, if their actions result in a breach, then they will be personally liable regardless of their intention. So, some common examples of breaches of trust includes A trustee invests the trust funds into a high-risk investment without seeking professional advice first. The trustee withholds trust funds from an entitled beneficiary. The trustee engages in self-dealing or accepts bribes. And also, a trustee fails to act when they witness another trustee mismanaging the trust property. So just these few examples should really make it clear what a breach of trust is. So now you know exactly what to look out for to identify a breach. Now imagine there's been a breach of trust. What can actually be done about this? And who can make a claim against a trustee for their breach? Well, if there's been a breach, someone will need to claim against the trustee to rectify the breach. The people who can bring a claim are beneficiaries who have a vested interest, meaning they are directly harmed by the breach itself. Then there are successor or co-trustees. And lastly, in cases regarding charitable trusts, it will be the Charity Commission or the Attorney General who will bring a claim against the trustees. So there's been a breach, there is someone claiming against the trustee, but what can they actually seek as remedy for the breach? Quick side note, remedy just refers to the legal means of enforcing a right or correcting a wrong, much like healing an open wound really. As we know, trusts are exclusive to equity in terms of enforcement. So the remedies will be what's known as restorative instead of punitive. So we aren't focusing on punishing the trustees. We are focused on returning the harmed parties to the position that they were in before the breach or harm actually happened. So let's now go through some common remedies for breaches of trust. First is equitable compensation, which refers to the trustee that was responsible for the breach. They will have to pay compensation to the trust for any loss caused by their breach, which will have to come out of their own pocket as they are being held personally liable for that breach. Next is account for profits. So this applies to trustees who have made unauthorized profits from their position, and therefore they must hand this over to the trust, even if the trust nor the beneficiaries were actually harmed. This is because trustees are not to benefit from their position as trustee, right? So when they do, and it's directly linked to their role as a trustee, then they have to give it all back to the trust, which, if you recall the case of Boardman v. Phipps of 1967, which we've discussed previously, this is exactly what happened with the solicitor, who was also a beneficiary of the trust. They had to give the profits to the trust, even though no one was actually harmed. Actually, quite the opposite. Everyone benefited from it. But that wasn't the point. The point was that the breach was a breach, regardless of a benefit or not. The third remedy is the imposition of a constructive trust. So in cases where a trustee misuses trust funds to acquire property or assets for their own benefit, then equity may impose a constructive trust over that property for the benefit of the trust. This therefore allows beneficiaries to trace the funds that were used to buy the property and also to substitute the assets back into the trust. A good example that demonstrates this is, imagine a trustee uses trust funds to buy a car. However, the trust deed did not allow for this to happen. So the result would be that the car would therefore be held in constructive trust for the benefit of the trust. The fourth remedy is tracing and recovery. So when trust property is misapplied, it can be traced back to the beneficiaries if it can actually be recovered. So if the property can be located again. If it cannot be located, then instead beneficiaries can claim for a proportionate share of a new asset that is brought to replace the misapplied property. This can be seen in the case of Foskett v. McOwen in 2001, where part of the trust fund was used to buy part of an asset which was actually a life insurance. As this was a breach of trust, the beneficiaries actually claimed for a proportional share of the asset, which was the life insurance policy. The next remedy is injunctions and removals. So, an injunction is a court order that requires someone to do or to stop doing something. So, if a trustee has breached the trust, they may actually be injuncted to terminate their wrongful conduct by a court order. And in very extreme cases, it could be that the court orders for the removal of that trustee and appoints a replacement if this is applicable. Sometimes a removal is more appropriate where there may be a situation where there is hostility between the trustees and the beneficiaries, or the trustee is incompetent to act anymore, or if there has been severe cases of dishonesty and gross mismanagement of the trust as a whole. And lastly is restitution or rescission. So in extreme cases, once again, a court may actually order for the unwinding of a transaction or order for the return of improperly distributed assets, which is particularly important and applicable in cases where a breach occurred which then induced a contract afterwards, right? So fixing the breach is obviously going to impact the contract, where it may need to be unwound completely as if it never happened, because, well, it shouldn't have done really. If there was a breach, anything that comes afterwards is voided. So we've mentioned a few times that trustees will be personally liable if they breach the trust. But what does this actually mean? Well, liability refers to someone being held responsible for their own actions or omissions, so failure to act, where they will be held accountable for causing some sort of harm or loss or breach of duty. So that's what it means generally. When we are talking about trustees of a trust, however, their liability is both jointly and also severally. So trustees are held responsible for any breach that they cause themselves or that they allow to be committed by another trustee. So this means that co-trustees that fail to monitor or act on the wrongdoing of another trustee, well, they will be held personally liable just the same way. A case that demonstrated this was actually the case of Tito v. Waddell in 1977, where passive trustees were found liable for breach of duty because they failed to act when they were supposed to. They were held jointly and severally liable for this. So some examples of situations that lead to personal liability will include carrying out poor investments, failing to act when they witness a breach of duty of another trustee, making disbursements to the wrong beneficiary, profiting unjustly from their position, and so on. And as you would expect really, professional trustees are held to a much higher standard compared to lay trustees. So the typical individual who wouldn't be expected to know so strictly the laws of trusts, unlike a professional trustee who make it their job, right? However, lay trustees are still expected to act diligently and to do their best, especially to seek advice when they are unsure on what to do. So they will be treated the same way if they breach the trust, just as a professional trustee would experience. So this presentation has seen us go deeply into all sorts, including the definition of fiduciary and also examples of fiduciary relationships. We've gone over important duties that are expected of trustees in office. We've highlighted the importance of consent to office of trustee. We've looked at the trustee's rights to compensation for their work. We've looked at the appointment and removal of trustees. We've discussed what a breach is and given examples of breaches of trust. We've talked about who can actually claim against trustees who breach their duties and the remedies that they can seek. And we've also talked about the liability of trustees when engaging in breaches. And as we approach the end of this 5th presentation into all things trust related, I hope that this presentation has really clarified to you exactly what is expected of a trustee when they accept this role, because boy is it a serious job to do. And hopefully you can understand better the sort of outcomes that happen when a trustee does not follow their duties. So as always, if you found this presentation useful for you so that now you know exactly what to look out for, you can identify a breach as soon as it happens, then please leave a like, share it with someone else who can also know the same, and don't forget to subscribe for more law educational videos. Thank you for watching. Ciao for now!